Hi everyone, my name is Tim Goodwin and I am a member of the Yuin peoples of the south coast of New South Wales, and I'm also a barrister at the Victorian Bar. We are so proud to be launching the First Nations Cultural Capability Framework for the Victorian legal profession, a groundbreaking and first of its kind initiative to improve the experiences of First Nations peoples seeking legal support and representation in our state. I would like to start by acknowledging and paying my respect to the Wurundjeri people of the Kulin Nation as the traditional custodians of the land that I am on today. I pay my respects to their ancestors that continue to inhabit and represent stories of country, to their elders that continue to pass on those stories of country, and to their entire community who continue to learn and protect those stories of country. I also acknowledge that we are all on Aboriginal land across Australia and that sovereignty was never ceded. A content warning before we start. We will be discussing issues that may include references to Aboriginal and/or Torres Strait Islander people who have passed, self-harm, trauma, violence, abuse, and racism. We know that these conversations can and will cause discomfort and concern, so we encourage you to access supports available. We encourage Aboriginal and Torres Strait Islander people to call Yarning Safe and Strong on 1-800-959-563. You can also reach out to 13 Yarn, and Aboriginal and Torres Strait Islander men can call Dadi Munro's Brother to Brother line on 1-800-435-799. And anyone can call Lifeline on 13 11 14. Those contact details will be shared in the chat section. So back to the framework. This is an Australia First, First Nations-led collaborative effort by the Victorian Aboriginal Legal Service, Victoria Legal Aid, and the Law Institute of Victoria. It is well established that First Nations communities frequently experience unsatisfactory and inadequate interactions with legal practitioners, organisation, and the criminal legal system, often translating to poor justice outcomes. For too long has the administration of justice been a lofty ideal rather than a lived reality for First Peoples. The tragic and preventable death of proud Gunditjmara, Jaja Wurrung, Wiradjuri, and Yorta Yorta woman, Veronica Marie Nelson, and the subsequent coronial inquest further highlighted the urgent need for change across the Victorian legal profession. Coroner McGregor's recommendations following the inquest included mandatory cultural awareness training for Victorian lawyers, highlighting the importance of supporting legal practitioners to be more capable of responding to First Nations people appropriately and upholding their legal rights. Ultimately, this framework and broader project will strengthen justice outcomes for First Nations communities and contribute to reducing their disadvantage in this sector. Over the next hour and a half or so, we'll be hearing from an incredible panel of experts about the development of this framework, how it will facilitate the strengthening of legal practice in Victoria, and what it means for the future of the profession. Before I introduce the panel, some brief housekeeping. The webinar is planned to go for an hour and 30 minutes, and we will try to stick to that as closely as possible. The chat function is open. Please feel free to comment who your mob are if you're First Nations, and for everyone, what lands you are tuning in from. I can already see an amazing collection of those chat items already. The question and answer function is open, and we will have time at the end to respond to some of your questions. We encourage people to ask difficult questions and share your thoughts, but we will moderate, so please be considered with what you write. We will share a link to the recording of this webinar once it's finished. So keep an eye out on the various organisations' social channels for that. Thank you once again for joining us today, and I look forward to the conversation ahead. So to the most important people here, our panellists. First up, I'll welcome Nerita Waight. Nerita, would you like to introduce yourself, please?
Hi all, my name is Nerita Waight. I'm a Yuri or Ngarrindjeri woman. I'm the CEO of the Victorian Aboriginal Legal Service.
Thank you very much. Also joining us today is Ashley Morris. Ash, if you could introduce yourself.
Thanks, Tim, and good afternoon, everyone. I'm Ashley Morris, Gunditjmara Man, and Executive Director at Victoria Legal Aid for First Nation Services.
Thanks, Ash. Also joining us today is Adam Awty. If Adam, you could introduce yourself.
Thanks, Tim. Adam Awty, Chief Executive of the Law Institute of Victoria.
Thanks a lot. And last but definitely not least, we will have Fiona McLeay joining us shortly. Fiona is, of course, the Board CEO and Commissioner of the Victorian Legal Services Board and Commission. Finally, and with great thanks to both of them, Therese and Brooke will be our Auslan interpreters for today. Thank you both for joining us. Before we start our panel discussion, we're going to play a couple of short videos to get a real sense of why this framework is needed. The first video is from Kelly Flanagan. Kelly is a female First Nations artist with lived experience in the Victorian prison system. She's a proud member of the Fig Jam Collective and continues to advocate for those women who are still suffering inside prison. Kelly is also using her lived experience to write her first book. She spoke with VALS about her experience of the legal sector.
I'm Kelly Flanagan. I am a Wiradjuri woman and I'm here today to share my lived experience with the legal sector. Firstly, I'll talk about the lawyers who were culturally insensitive, and I feel that's quite important to start with because it looks a little bit different in every circumstance. But I think initially when you're in a room with a lawyer and there's that really big power imbalance, so the corporate suit and the room and the language is huge. Initially, well, you just want to disengage. You don't want to engage with that person. So I think it's really important to keep that really personal touch. Use your interpersonal skills as to be on the same level. Basically, aren't acknowledging the person as a person. You just acknowledge them as a case. You sit in, you go, look, let's get to the matter, and you're going through paperwork. You're not listening to them. You're not listening to their story. You're not giving them options, just speaking at them, not to them. If you're ever dealing with a female Indigenous woman, I think really understanding that you could say one wrong thing that could potentially jeopardize your relationship with that woman. And that doesn't just turn her off you as a lawyer, that turns her off all lawyers. The statistics of us already engaging in or being engaged in domestic violence and, that kind of stuff coming into custody or before going into custody is extremely high. So we really need that cultural sensitivity when it comes to verbal communication. Highlight for me when being represented by my lawyers was the acknowledgement to me and my ancestors and story. I mean, without going into it too big performance, it was just a genuine, I acknowledge, I see you, I acknowledge you and your people. And I think cultural sensitivity for me as an Aboriginal woman, it's, ensuring that you see me and hear me and respect what I'm saying to you. My whole experience in and out of the justice system, I have been pushed down. I've been told that I'm nothing, that I'm worthless. I've been, tormented by officers. And when I came across my lawyer that represented me, she made me feel I was so strong. She made me feel so accepted, so valid, and so powerful as an Indigenous woman. She didn't make me feel like I was not relevant, just a number. And, she listened to everything I said. I'm sitting here today and I am this powerful and I am this strong because of the work that she put in. It may not seem like much to her, but her actions has created an absolute powerful person. I'm not scared to say that I'm a First Nations woman. I'm not scared to say that anymore like I was before. I would be very ashamed almost of it. And working with my lawyer who's super culturally sensitive, she's brought out this spark in me, this beauty in me, and it just makes me want to be a better me. I think the training is so important because it gives you the opportunity to understand things about us that you might not know. You can be super culturally aware. But I think if you're getting training from First Nations people and people with lived experience, I think there's something you can always take from that. Lived experience people, it is what it is. We are lived experience. These are things that we have experienced, and we share them with you because we want to engage and connect with you. I think what you can take from this is truly being a better person moving forward. And it's just a better way to do things. It really makes us feel part of the community.
Thanks so much, Kelly. Next, we have a video from Magistrate Jill Pryor, OAM. Magistrate Gillian Pryor was appointed to the bench in May 2024, following their honours service as Principal Legal Officer and co-founder of the Law and Advocacy Centre for Women, a role their honour held from 2016. Magistrate Pryor brings extensive experience to the judiciary, having served in senior roles across several key organisations, including as Principal Legal Officer at the Victorian Aboriginal Legal Service, where their honour worked for 11 years, the Aboriginal Family Violence Prevention and Legal Service, now JIRA, and the Fitzroy Legal Service. In 2018, Magistrate Pryor was appointed to the Women's Correctional Services Advisory Committee. In recognition of their outstanding contributions to the legal profession, Magistrate Pryor was awarded the Order of Australia in 2021. Magistrate Pryor spoke with us about effective advocacy for First Nations clients in the justice system.
My name's Jill Pryor, and I am currently a magistrate sitting at the Magistrates Court of Victoria at Melbourne. The role of a legal practitioner is to advocate on behalf of the client. What that involves is understanding the law and understanding evidence, understanding the audience, and understanding the person that you're representing. Now, so if you weren't engaging previously as a practitioner who's representing somebody who identifies as First Nations, this is a terrific starting point. This is where you should look to say, okay, well, these are the things that I actually need to consider, turn my mind to. It's not up to the person that you're representing to teach you things that we know. It's almost like you're at the optometrist and there are a series of lenses that are going across, and each one has a different job to do. So when you deliver your sentence, as in a spoken word sentence, you are delivering it through those lenses. What happens when you meet your client is they will tell you a story. You will then reframe that story, and if you do it well, you'll reframe it in a way that holds the integrity of the story, filters it through so that it populates the spaces it needs to populate in a legal context, in a courtroom, in that framework. And it will do that in a way that empowers your client, makes them feel they are heard, they are represented, they are advocated on behalf of. It has always remained with me, and it has come back to remind me ever since, so probably for the last 20 years, to listen to what somebody is saying, to understand that this is their life that they are telling you about. And court is terrifying. It is traumatic. Nobody wants to be here. It is a place where really significant events happen, and for the person that is brought there, not because they want to, but because they must, you must listen to what they are saying, place their story in what you understand to be the broader context of their life and the history of Aboriginal people in this country. And if you can't do that, you are not advocating on behalf of your client at all. Many years ago, a young Aboriginal bloke said to me, in custody, I asked him, what does it mean that VALS is representing you? And he wasn't somebody who spoke much very often, but he said to me, it means I don't have to explain everything. I don't have to try to upskill, and he didn't use these words, but I don't have to upskill the person that's going to represent me. I just know. And that's profoundly important. And it's really unacceptable today in 2025 for anybody to say they don't know what those histories involve.
Oh, thanks, Magistrate Pryor. So let's kick off with the panel and talk to Nerita first about how the project came about and the rationale for the framework. So Nerita, we've heard from Kelly and Magistrate Pryor about why this framework is so important, and particularly struck by the importance of storytelling and listening to someone's story in a way to be an advocate for that story as a lawyer. So can you tell us a bit about the story of the framework and a bit more about its detail and why it was chosen to address the issue of inadequate legal advice and representation for First Nations communities?
First off, I just want to acknowledge how beautifully Kelly really told the story of so many of our mob who experience the justice system and the artificial way in which often justice is delivered. Also want to thank Jill for all of her work that she's done over the years, particularly here at VALS and now as a magistrate, and also thank her for the free advertisement of why VALS is such a great place to work. And you are all welcome to come aboard if you choose. In terms of the framework, I just want to know that this isn't something that has just sprung up out of the ether. This has been 3 years of hard, intense work with over 90 different consultations with key stakeholders, legal experts, and most importantly, our mob with lived experience of the legal system. And I extend my deepest thanks to all of those who were involved. The framework comprises 3 areas, so key knowledges, attitudes, and skills that legal practitioners need, which are broken down into 13 capability domains. These domains are underpinned by principles like self-determination, truth-telling, cultural safety, and cultural respect. And we've designed a framework to be applied at the individual practitioner level and also at a foundational level. And this isn't something that is just relevant for law students, but also, legal practitioners, solicitors, barristers, even the judiciary itself, which could do with some help. Now, to answer why a framework was chosen to address the harms faced by First Nations communities, it's a way to chart the terrain of capability and facilitate a shared understanding of the skills, knowledge, and attitudes of culturally safe legal advice and representation. It also provides the foundation for designing effective training for the sector. And as a lawyer, you should be able to pick up this document and at a glance understand, at a very broad level, of course, what it is you need to strengthen or learn about to do a good job for our community. This framework can also help managers and organisations to have conversations about the professional development of their staff. But this isn't a one and done, Tim. This isn't something that you just rock up, you do a day or day and a half, and it's over. What the framework is about is tiering learning and engagement to make sure that you have a chance to apply it, then come back and reflect on what worked and what didn't, to have that community of practice and to really build cultural capability over time. We do hope that this is something that the legal sector embraces at all levels, and we do see the change that we need, particularly in the context of entering our first treaty this year.
And you've mentioned, the very nature of a framework is that it sets up broad guidance for what should and must be done in terms of cultural capability. What's your vision for how the framework will be implemented?
Yes, well, whilst of course I, as the Victorian Aboriginal Legal Service, would adore that this be a requirement for every legal practitioner, from law student to solicitor to barrister to judiciary, to be engaged with, I hope that we see that broad take up. We will be running a pilot of a foundational training and best practice guide to be developed in alignment with the framework later this year, before, of course, rolling it out formally to a broader profession next year. The foundational training that will be offered is applicable to all legal professionals and is a necessary step in their journey to being culturally capable in the eyes of community and the clients we see each and every day. Particularly noting that, just to give a sense of reality, I used to be a lawyer. I like to call myself a reformed lawyer. And each and every day I would see people who were fronting up to the legal system who had just seen bad outcome after bad outcome. You would see lawyers spend maybe 5 minutes at best, Tim, maybe 10, maybe 15 if we were lucky, to understand their story. And then they're supposed to reframe it through the lenses that Jill talked about. And that's not sufficient. And I hope that not only will we see people change the way in which they consider representing Aboriginal people, I hope that it also changes the way they engage with people at a human level, that they understand they need to spend more time learning and listening in order to reframe.
Yeah, I've often thought about and counted the 6 minutes that Veronica Nelson had with a legal representative before her bail hearing, and it's amazing how quickly that goes when you think about someone completely understanding, assessing and analysing the legal needs of a client who is facing incarceration as an Aboriginal woman. It's just, I often think about that figure a lot in that context.
I think it needs to be understood in the context that, as we know as Aboriginal people, but what is probably not as widely understood out there, although I hope the Walk for Truth has gone some part into engendering this understanding, is that when we walk into a court, we face generations of discrimination, and we see it at all levels. Often that person who is fronting court, they've had family who have been incarcerated for generations. They've had family who've had their children removed generation after generation, and they're coming in that with all of that trauma, and 6 minutes isn't enough to unpack that.
The final question, Nerita, how do you see the framework fitting with broader goals around building First Nations cultural capability?
It's important to see the framework as a real small part of a larger system change approach. As we know, training isn't a cure-all. It has to be supported by a range of levers that enable behaviour change across the individual organisational professional levels. I've situated the framework within a broader theory of change that outlines further work to be undertaken across implementation supports, compliance and accountability, and advocacy. With the framework established, we and of course our partners in terms of Victoria Legal Services Board, LIV and VLA will be working to the longer term goals that the theory of change envisions.
Wonderful. Thanks, Nerita. So to shift toward thinking about the framework at an organisational level, we have a short video from Toby Hemming, the CEO of Victoria Legal Aid.
I begin by acknowledging and paying my deep respects to the Wurundjeri people of the Kulin Nation, the traditional owners and custodians of the lands and waters where I am today, and I extend that acknowledgement to the many traditional owners of the various lands you all join from today. I pay my respects to elders past and present, and I extend that respect to all First Nations people who are here today. I recognise that sovereignty has never been ceded. I also support and acknowledge the critical importance of treaty. My sincere apologies that I couldn't join you online. My great colleague Ash Morris is representing Victoria Legal Aid today. Ash is the inaugural Executive Director of VLA's standalone First Nations Services Directorate, which was established just last year. This directorate leads and supports projects and initiatives that aim to address systemic racism and disadvantage. Ash has done some incredible work on this particular project, alongside our partners at the Victorian Aboriginal Legal Service and the Law Institute of Victoria, among others. This First Nations-led framework is such an important step towards long overdue change in how legal services are provided to those First Nations people involved in the legal system. At Victoria Legal Aid, we know it's critical we do our part to support an improvement in the cultural capability of legal practitioners. To deliver quality legal aid services for First Nations people, it is necessary for both Victoria Legal Aid's lawyers and for our panel practitioners to have access to First Nations designed and delivered training. At Legal Aid, we're very proud to support the Victorian Aboriginal Legal Service in partnership with the Law Institute of Victoria on this critically important project. Working with First Nations people and organisations and guided by the principles of self-determination, we're deeply committed to ensuring First Nations people have access to culturally safe, inclusive and responsive services, as well as a voice in shaping legal and other services that affect their communities. This framework demonstrates once again the importance of First Nations leadership within our sector and in Victoria, particularly by the Victorian Aboriginal Legal Service. VALS has played a vital role for over 50 years, not only to deliver its many legal support services to First Nations people and communities, but also for ensuring First Nations experiences and perspectives shape the positive change in justice outcomes that we know must come. We see VALS upholding the dignity and rights and demonstrating the resilience of First Nations people every day, right across the state. And through this project, we are joining with VALS to help address inequality within our legal system. Change is long overdue. The Victorian legal profession has often not delivered culturally safe and responsive services. Indeed, Uruk's recommendations are clear that anyone involved in the criminal justice system should have the capability, competence and support necessary for them to carry out their obligations under the Charter of Human Rights and Responsibilities Act and other human and cultural rights laws. And following the 2022 coronial inquest into the tragic and preventable death of Gunditjmara Dja Wurrong, Wiradjuri and Yorta Yorta woman Veronica Marie Nelson, Coroner McGregor stressed the importance of helping legal practitioners to be more capable of responding to First Nations people appropriately. So we welcome an approach to an uplift in cultural capability for the legal profession that is First Nations designed and led. This framework sets the right course for change. Thank you to everyone who brought their considerable expertise and lived experience to this work. We're excited to take the next steps with you on this journey and help our shared hopes for improved justice outcomes become a reality for First Nations people. Thank you very much.
Thanks to Toby for that message. So, Ash, thanks for joining us today. We can see from the discussion with Nerita just how big the goals for this project are. And Toby has spoken about Victoria Legal Aid's commitment to this work. What is the potential for a framework like this at the organisational level? So, from your viewpoint, for example, how do you think it could strengthen the practice of VLA staff?
Thank you, Tim. As Nerita said, that the framework really is just the beginning of a broader journey, but the opportunity it provides Victoria Legal Aid and other legal professionals is the opportunity to be guided by First people and what they set the standard of what they expect to receive when engaging in seeking legal assistance. The framework will assist us as an organisation to develop culturally safe services by providing a community of practice and training offerings. It is a journey. We're not going to nail it in the first round, as Nerita said. We're going to pilot it and take some learnings from that. But it'll provide an organisation like Victoria Legal Aid with the opportunity to provide those supports to our staff, our panel practitioners, with access to be able to apply those lenses Magistrate Pryor spoke about earlier. We're a non-Aboriginal legal service at Victoria Legal Aid, but that doesn't mean we can stop there. We still need to be able to provide culturally safe, culturally responsive services. This framework, the implementation phases to come, will assist us in doing that. We'll be able to ensure that clients experience culturally safe, accessible and inclusive and respectful services at the discretion of the community. You know, this is a First Nations led initiative. This isn't non-Aboriginal organisations setting that standard on behalf of Aboriginal people. This is a true transfer of resource, power, decision-making in an attempt to address trauma, support healing through the legal profession where we know we're so overrepresented.
So you've mentioned some of the supports that you're hoping to be able to provide for VLA staff. Can you give us a bit of a sense of what those supports might be for VLA staff to engage with the framework?
Yeah, accountability to community is, I think, an unwritten sort of opportunity, something that this framework brings. An easy access point to First Nations perspective, given that it's led by the Aboriginal community controlled organisation in Victoria, in VALS. So engaging that as a partner, but also as a participant of the legal profession, we're able to have access to First Nations designed and delivered training for our staff, our panel practitioners, to strengthen practice to uphold justice for First Nations people.
And we know that this framework is the foundation for broader uplift and that training alone cannot achieve that kind of change. What else more broadly, from your perspective, does VLA have planned to support First Nations culturally safe and responsive legal support?
Yep, recently we've expanded the work of our First Nations Services team, and I see a few of them in the chat today, so I want to acknowledge them for doing this work in the space they did in the past, you know, as representatives of Victoria Legal Aid. But, you know, one of our key priorities is to implement this framework to the work we do. So that's looking at our practice standards, our quality audit function, our legal supervision, our ongoing development of our in-house staff and panel practitioners to build in, or was really to look at how they're currently supported to build their cultural capability and bring in First Nations-led initiatives to assist that journey. We know it's not going to happen overnight. There's a lot to learn. There's a lot of areas of the law that we can apply these lenses to, but it really is a key priority for our organisation the next 12 to 18 months to implement this framework within what we can. This
is a bit of a question without notice. Sorry, Ash.
Thank you.
How do you make sure that the burden to make sure that these types of frameworks are implemented and delivered on don't become the overwhelming burden on First Nations staff? Do you have any, so that it just adds cultural load to First Nations staff in an organisation? So how do you, from your perspective, how do you strike that balance between First Nations led and the undue burden of leadership that sometimes comes for First Nations staff?
Yeah, thanks, Tim. It's a really good question. and a really hard line to balance. I guess the legal profession have an opportunity through this framework to do their part, to walk with us. I mean, Commissioner Lovett just walked 500 kilometres with many non-Aboriginal people to understand, what's been happening in this country through a royal commission. And the framework provides that for the legal profession. This is really an opportunity now for the legal profession to roll the sleeves up and jump in and get on board with this framework. We can't do it without you. And I'm sure Nerita, if was asked that question, would be saying the same thing, that we have the framework that sets out what the expectation is at a base level, and we'll be giving the legal profession those tools to jump on board and better understand it. We're not expecting this framework to be the end of racism in the legal profession or the justice system in Victoria, but it's a pretty clear pathway that's been led by First Nations communities with lived experience and Aboriginal community control to open the door to say, jump on this journey with us. This is an opportunity for the whole legal profession to strengthen practice and uphold justice for First Nations people.
Thanks, Ash. Well, you've provided a perfect segue to ask Adam some questions in relation to the broader legal profession. So, Adam, Ash has spoken about what needs to happen at the organisational level to support and uplift of First Nations cultural capability, but also recognise the importance of the entire profession joining this journey and committing to these issues. So we know change needs to happen at the level of the entire profession. Can I ask, why did the LIV become involved in this project, and what do you think the LIV's role is in supporting the framework?
Thanks, Tim. And obviously from our perspective, it's been evident for a long time that there needs to be sort of systemic and system changes in the way the legal profession advises and interacts with First Nations people. And from our perspective, obviously the cultural capability framework, which has been developed, is a vital step forward in providing culturally appropriate and safe legal assistance for First Nations people who are actually needing or intersecting with the legal system. I think, as has been said earlier, it's not the be-all and end-all, but it is a vital step in that journey to really start to educate the legal profession. From the LIV's perspective, we've been involved in supporting the development of the framework as part of our commitment as an ally to change outcomes for First Nations people, obviously as they interact with and come into the legal profession and the justice sector more broadly. We're seeing formal cultural capability uplift programs across other sectors, and we have a long time, whether it be in the government, whether it be the health sectors, particularly in the legal sector, given the disproportionate impact that our laws and our justice system have had on First Nations peoples. The development of a framework with and for culturally capable delivery of legal services, in our perspective, is long overdue. And obviously, we think this framework is a critical step in that. Obviously, with the impending release of the report of the York Justice Commission, and obviously with our negotiations towards treaty in Victoria, the framework comes at a pertinent time for change. The LIV is proud to support First Nations cultural capability framework, and obviously we're honoured today to be part of that panel.
Thanks, Adam. And so in terms of supporting the framework itself, the Law Institute as essentially the peak body for practitioners in the state, what is the LIV hoping to do to encourage legal profession? Well, what is the LIV hoping to encourage legal professionals to do under the framework?
Thanks, Tim. Obviously, we encourage all practitioners to engage with the framework, to understand what it does and how it can help improve their understanding of the nuances of engaging with First Nations clients. But it's not only about supporting the legal practitioners to represent First Nations clients more responsibly. It's also about helping to make sure the legal profession and lawyers working in the profession are well-rounded and are able to support the entire system in practice. Cultural capability, in our perspective, strengthens all aspects of legal practice, and the framework presents an excellent opportunity for practitioners to diversify their skills and expand their areas of practice. We really do encourage and really want to support practitioners to engage with the framework and to grow their capability. The framework is not only for those in the obvious areas of practice like crime, family law and children's law. We believe that building culturally capable practitioners and lawyers who have a better understanding of the nuances of the individual clients will enhance all areas of practice. And that's going to become increasingly important as we move forward. Legal practice is forever changing, and it's important to understand how the legal profession and practitioners more broadly deal with clients and support clients at the very difficult times as they intersect with the justice system. and making sure that we as the LIV provide appropriate training and support, obviously as an ally and partner with VALS and others, to deliver that capability training over the years to come.
And I think that's a really important point that you make about the framework being broader than only those practice areas where Aboriginal and Torres Strait Islanders are thought to have engaged the most in terms of crime, family and children's law, but actually First Nations people engage across various areas of law. An obvious example, I think, is just the proliferation of Indigenous corporations that are subject to specific regulation and the burden on community members to be directors and comply with directors' duties and understand all of those things, whether it's a native title PBC or a local enterprise in terms of a First Nations business, or if it's a corporation representing the interests of particular traditional owners. I'm hopeful that corporate lawyers engage and consider they need to engage with this framework as they go forward. I just wondered if you had any reflections on that need to really ensure that legal professionals don't think this is confined to potentially stereotypical concepts of how First Nations people engage with the justice system.
I think that's spot on, Tim. And one of the things that we were really conscious of from the beginning of the conversations with VALS and with VLA and the Legal Services Board and Commissioner around cultural capability framework was the danger was that it would actually be seen as an issue for the traditional sort of stereotypical areas of crime, family and children's law. But as you quite rightly pointed out, Tim, the intersectionality of where the law will intersect First Nations people and clients is going to be broader than that. It will be in property law. It'll be understanding what does it mean for giving advice around wills and estates and bringing in traditional customs and issues that come through that lens. How does the broader intersection of law LAW and law LORE actually start to intersect more broadly and get the entire profession to understand what their obligation is to make sure that they do spend some time investing in actually educating themselves about what does it actually mean to provide that support across all areas of law. And as you said quite rightly, Tim, one of the things we want to make sure is that whether you're in Collins Street, whether you're in Warrnambool as I am today, running a small practice in property or wills and estates, it is just as important to actually invest in understanding the cultural capability requirements as a legal practitioner. And it's not just isolated to those traditional areas where people might think that this is of more importance. That said, clearly there is a lot of important work to be done in those areas because the consequences of getting it wrong is much graver. But it doesn't mean that everybody else can sort of turn a blind eye and say, well, it's obviously for criminal lawyers and family lawyers and children's lawyers.
Yeah, it's a good point. And also, I think it's important just to recognise, it just makes you a better lawyer. So it's not only for Aboriginal and Torres Strait Islander clients, all your clients will benefit from you being, from a legal practitioner being culturally competent or increasing their cultural competence. It might be an unattainable perfection, but on that journey of cultural competence, because that's just going to mean you listen harder to your client's story, to any story that you might hear, and that's going to make you a better lawyer. I remember being... Oh, sorry, you go, Adam. Yeah.
I think it's spot on, Tim. And one of the things that I often talk about, the law is a service-based profession. Ultimately, it's about human interaction. So investing in understanding the human consequence of the stories of your clients and what their background is, what are their special requirements that they may have, this is actually, to your point, this is actually making you a better human and a better lawyer at the same time, because all it is doing is investing in a understanding of, in this instance, obviously the nuances of how you better support First Nations clients, or how do you better support your colleagues who may even be First Nations people within the law to make sure it's culturally safe. And we should want that, for all areas of the profession, to have a culturally safe way to navigate the legal system, which is quite vexing and quite complex at times. And also to pick up on one of your points, I think you asked Ash, Tim, and one of the things we're also conscious of, and this is obviously why the LIV has been really strong in wanting to partner, obviously, and be an ally with VALS on this, is we can't keep expecting Indigenous people within the law to wear the cultural load of this. Obviously, it has to be First Nations determined and informed But we, as the peak body for the law, needs to actually make sure we're actively taking a role in promoting, advocating and supporting this under the appropriate auspices of self-determination.
A final question. What do you hope will change as a result of the framework?
I hope we're not having to have these conversations in 5 or 10 years' time, if I'm being frank, Tim. This is just a way of practicing. We have more culturally informed practitioners who are invested in understanding it. They're asking questions, they're listening and they're hearing the stories of their clients. And then in an ideal sense, we are not having the tragedies that have come before us, which have informed coronial inquest after coronial inquest and the like. And that this conversation is not so much about looking at the basic level we're at now, but we are much more invested and developed within the profession as just the way of practicing and what, as you said before, what being a good lawyer is. And it's from Collins Street to Kahuna, right through to big law, small law, legal assistance to corporate law, which is part of the way lawyers practice in Victoria. And we are taking the lead as leading the way in Victoria. I'm trying to actually bring this to life.
Thanks, Adam. Just while we have some personnel change, I'm reminded of when I was one of the junior counsel assisting the Royal Commission into the protection and detention of children in the Northern Territory. We talked a lot about how to make youth detention facilities much more culturally safe for First Nations kids and an academic. We were interviewing an academic and one of the lawyers on the team asked, but is the worry that we're assuming that it will only ever be Aboriginal and Torres Strait Islander kids in detention? And her answer was, you're assuming that a culturally safe space isn't as good for a non-Indigenous kid as it is for an Indigenous kid. And I think that is really important when we're talking about that uplift for everyone, that it's going to serve the profession generally. So welcome, Fiona, as well. Thank you very much for being here. Just some questions from you as the regulator for what you think the framework means for the profession going forward. What do you hope members of the profession will take from this framework and the subsequent training offerings that are designed to implement it?
Yeah, great. Thank you. Apologies for the slight technical challenges that I've been facing. So I'm obviously not Adam Awty, but Adam's kindly letting me sit in on his computer. Yeah, I just want to also acknowledge that I'm on the beautiful lands of the Eastern Maar people, not far from where Commissioner Lovett started his walk. I was at Whitten Oval last week to see almost the end of that, which was terrific. I also want to acknowledge that I am a descendant of colonisers and I was born on Gurindjeri country in South Australia, and I just think that's appropriate to make that acknowledgement as well. In terms of what I hope the profession will take from the framework, really I hope and I also expect that the profession will embrace the framework with the generosity of spirit with which it has been collaboratively developed. There's a lot of opportunities that come with this framework, and I'm sure people will recognise that, not just for particular areas of law or particular client groups, but as we've just been discussing, more widely across the profession. This should just be the way that lawyers work. We are the inheritors of the common law system, which has been often violently imposed on top of the millennia-old systems of law and law of our First Nations peoples. And we need to understand that and stand in the spirit of that as members of the legal profession, regardless of the particular areas of the profession within which we practice. So I really encourage lawyers to use the framework as it's intended, which is a reference point for identifying areas where you need to grow your own First Nations cultural capability and to structure professional development accordingly. Cultural capability is an ongoing journey. That's certainly been my experience, many years of a lot of self-learning myself. There's a lot of resources out there. You don't need to be imposing your ignorance on First Nations people, but there are also opportunities to engage with First Nations peoples and to learn. And so this ongoing reflective practice is something that's built into the framework and is absolutely vital. For organisational leaders, I think there's the same opportunity. It's a reference point for identifying areas where your staff need to develop, but also to think about changes within your organisations, policies, procedures, leadership development, so that the uplift is not just left to individual lawyers, but is an organisational uplift and one that can be sustained. I also would like to see the development of communities of practice, networking and mentoring relationships where we can learn from each other and support each other as we embed what is within this framework. Ultimately, I think what we want to see is meaningful relationships with First Nations-led legal and other services and practitioners to learn about the histories and communities in which we practice, and take that time to learn and maintain reciprocal and respectful, genuine relationships with local First Nations and traditional owner groups. And yeah, it has to be reciprocal. As I said, we need to be careful about how we do this and make sure that, we're taking the responsibility ourselves to learn. So there's some of the things that I hope will come from this framework, Tim.
Thank you very much. We know that becoming more culturally responsive is not a destination, it's a continuing journey. What do you say as the priorities for ongoing First Nations cultural capability uplift in the profession into the future?
Yeah, well, the great thing about this framework is that it's a consistent foundation and structure for capability building across the whole of the profession. I think that's really important. As I said, it's not just about individual people who are enthusiastic, but a framework that can apply across the whole profession. We've also got a clear mechanism for lawyers to assess their own cultural capability and then build that into their development CPD products that we as the regulator promote, and that the professional associations, in particular the LIV and the BAR, can support and promote to the sector. I think the development of training products that align to the framework is critical. The increased availability of First Nations developed and led training is only going to produce better outcomes for individual lawyers and First Nations clients. That's certainly been the experience of my own organisation as we've embarked on this journey ourselves. Working with a First Nations-led organisation has been very profound for us. It's also part of a larger systems-level change. That's something that at the Board and Commissioner we're very passionate about generally. We've done some work in wellbeing where we've looked at the whole system, and that's definitely the case with this issue as well. A whole lot of different implementation levers need to be there to facilitate the kind of change we need at individual, organisation and professional levels. The framework's practical as well, which is terrific, and I think that's really important. We'll be using the framework to set clear expectations about what First Nations cultural capability looks like as an expression of legal best practice, and to really promote the uptake of the framework. And I'm very proud to be able to lead the charge on this. I actually think that there is appetite within the profession to build better understanding of First Nations cultures and practices, and many who clearly see that this best practice delivery of legal services requires this. We have done some research recently at the VLSB with our lawyer census, which is the first time that we've done that, and some of you may have participated in that, so thank you if you did. We're currently at the results from the lawyers who completed the survey, but a key area we asked the lawyers about was the competencies which they felt were required for legal practice. And one of those competencies, across 38 of them, was First Nations cultural awareness and safety. And I was actually really encouraged that 2/3 of all the lawyers who responded agreed that First Nations cultural awareness and sensitivity was critical, very important, or quite important to their legal practice. So you could flip it around and say, well, 1/3 of them didn't think that, but I think it's good that we're starting from that base where 2/3 of lawyers are saying, actually, yeah, I think this is important. There's definitely, I think, for the implementation of the framework. Yeah, as I say, that's really encouraging, plenty of opportunities. Young practitioners in particular were more likely to rate cultural awareness as very important, which is perhaps unsurprising, but is really positive as well. Community sector and government lawyers, markedly higher responses. 74% of community lawyers and 65% of government lawyers said that raising awareness is very important or critical, which is really, again, very encouraging. So that survey research will help us identify the cohorts where we might want to focus our attention, as well as refine the offering. So we'll be looking more closely at that lawyer census results, and we will be doing that regularly. So we'll be able to see a shift, we hope, over time.
What would your message be to the third that answered differently? So think about, a partner of a small firm, employs 2 lawyers, works in various aspects of commercial law for small businesses, and to the best of their knowledge has never engaged with an Indigenous opponent from another law firm, or engaged an Indigenous barrister, or had an Indigenous client, and says, no, well, it's important, but not really for us. Isn't anti it? What would be your message to them?
Yeah, it's a good question, Tim. I think it's one we're all going to have to grapple with. I have been asked this question. My answer at this stage is that it's similar to what I started with at the beginning, that as lawyers in Australia, in Victoria, in the common law, we need to understand where that came from. All lawyers study law through that lens, and indeed the common law itself is one that looks backwards to look forward. So I don't think you can really be doing your job properly if you don't have a sense of where those laws came from and the way in which they have been exercised over time and to impact in Aboriginal and Torres Strait Islander people. I tend to put it in that kind of broader context initially, to say you need to understand, the context within which you apply the rules and the laws and interpret the cases that you use in your everyday work. I think also, as you said, they may not know whether they're engaging with First Nations person or not. So assuming that it's irrelevant, I think is something people shouldn't be doing, and they need to be a bit more aware of that. And so this training will help them in that regard as well. But I do think it's something we will have to explore as we implement the framework. How do we help to answer that question and make it relevant over time?
And one thing that's important about the framework that's connected to part of your response, which is around that organisational and systems level, rather than only thinking about the individual practitioner, but how do we build organisations, communities of practice, those types of things. One thing that I think is important about the framework is that it's about non-legal staff in legal organisations as well. I think about a whole bunch of research that shows that the most important person to an Aboriginal or Torres Strait Islander accessing health services is the receptionist or the first person that they see at a hospital or at a health clinic, a determinative factor about whether they get care or not. And so that might not be a lawyer in terms of legal services. I know, your powers only extend so far, obviously, but, do you have any reflections on that issue of making sure that this covers everyone?
Yeah, no, I agree with that. I think you're right. The other area, of course, is websites. We've just, again, done some work on our own website at the Board and Commissioner. Yeah, unsurprisingly, perhaps the feedback from our First Nations colleagues has been that it doesn't feel particularly culturally safe at the moment. So we've got a clear, pathway forward to change that. So even before you get to the receptionist, you're going to be looking, at the website. So I think there will be people across all parts of a law practice who will be interested in this. And so that organisational perspective and aspect to it's really important. And the system change can happen at all levels of an organisation. So I think it's really important for those of you that are from law firms that have those broader kinds of resources to not be thinking just about yourself or the lawyer you're working with, but think about making it something that the whole of your practice does together.
So final question, and just to remind people to think or shift into the Q&A portion. So please, if you have any questions, put them in the Q&A function. I know some have been coming up in the webinar chat, but it's a bit harder for us to see those questions. So please make sure that you use the Q&A function, but we'll do our best to get to all of them. So a final question for you, Fiona. As you may know, it's NAIDOC Week in a couple of weeks, and the theme is strength, vision and legacy. How do you think this framework speaks to that theme?
Yeah, such a great theme. And 50 years, I think, of NAIDOC Week, which is fantastic. Yeah, really, really amazing. I think the full theme is actually the next generation strength, vision and legacy. And again, the framework really speaks to that. We can't ever lose sight of the past, and indeed the past is not so far behind us, but the framework is forward-looking. It's looking to really build the current generation, but also the next generation. And I think, as I said before, that research that showed that young lawyers are really enthusiastic about this is very encouraging. So we want to make sure that we have a culturally responsive and safe legal workforce, which will improve the experiences of both current and future generations of First Nations peoples. As Adam said, we don't want to be sitting here in 5, 10, 15, 20 years' time having the same conversation. The theory of change that underpins the framework has a clear vision to help transform First Nations people's experiences of the legal system. And an inherent part of the framework is that it's First Nations led and tailored specifically to the legal profession, and takes a strength-based approach to building cultural capability and knowledge. In terms of legacy, the framework places a lot of emphasis on truth-telling, which is absolutely critical. Before we started a RAP process, we did a truth process, and it was incredibly powerful and has underpinned everything that we've done since then. So I think the importance in the framework of truth is really, really, really important to understand. And it goes back to your question in a way, Tim. If people understand the history of First Nations people and the continued and ongoing impact of colonisation and the role of the law in that, that will be really important. And the framework itself honours the legacy of elders and ancestors, which I think is really important. So I think there's a lovely kind of synergy between the framework and the NAIDOC theme of strength, vision and legacy.
No, thank you very much. Well, we'll move to some questions and please continue to put questions in the Q&A chat. Might kick off one for you, Nerita. And this is, we talk often in the field around cultural awareness training and the importance of that, and various organisations invest significantly to have their staff do that. Can you tell us a bit more about what advantages this particular cultural capability framework offers compared to baseline cultural awareness guidelines or training?
Yeah, sure. First off, cultural awareness training often is just about trying to give a general overview of what First Nations peoples have experienced as a result of colonisation and resulting policies. What this theory of change, what this framework does, which is underpinned by a theory of change, is take that and build upon it, to understand that engaging, and this is based, it's not just my word, this is based on extensive research and experts, that engaging in that one-off training, of course, can be valuable. But in order to achieve sustained practice and attitudinal change, you need to do it on a continuum. That means that you need to start foundationally and then build upon it year on year. And what we really worked through with our lived experience clients who assisted us, of course our advisory group and all of the experts that we engaged with, was that it wasn't just a simple online module. It wasn't simply a face-to-face element. What they needed was things like specialist training for individual practitioners that then built upon their area of practice. They need implementation supports like leadership training, organizational-led championing and training, communities of practice, compliance and coaching and supervision. And they need to be held accountable through compliance and accountability measures. And they wanted to see advocacy measures like sector championing and advocacy for change within government, courts, regulator and the profession. And I think for me, as an Aboriginal woman, what I was really touched to see, not only just through the discussions with our lived experience, but through the advisory group, was how in alignment they were, how everybody could see what the problem was, everybody understood what the journey needs to be in order to change that. And they understood that there was a mixture of things we could do in the short term, things that we could do in the medium to long term. That would mean that one day having a culturally capable legal sector will just be the ordinary part of how the justice system operates. Sure, there's a lot of things I would like to change within the justice system, but this is one in which we as a profession have the responsibility to change, and it is within our power and grasp to do so.
Thanks for that. Ash, just switching to you, given your past experience at the Children's Court, why is it important for this project to offer not only foundational training, but specialised modules for practitioners?
Thanks, Tim. Just quickly following on from what Nerita was saying, the beauty, yes, we're starting with foundational training, this framework, but what is really of importance is that it's designed specifically for the Victorian legal profession. We're talking about Koori people's experiences of the justice system is what will be guiding these trainings. We often hear as Aboriginal people, I've worked up in the Northern Territory, so I understand community, and that's, no disrespect to the mob up there, but we're on Wurundjeri country. We need training based on Wurundjeri experiences or Gunditjmara experiences, wherever you are in Victoria, and that's what this brings. In terms of specialised modules for practitioners, you look at what our elders have fought for, the Aboriginal child placement principle. We got more kids in this state in out-of-home care with no connection to their siblings or their mob. When we have it legislated, and through this framework and hopefully the specialised training modules that come to follow will give us the tools to be able to make those submissions that, hey, this is a Gunditjmara kid and talking about child protection here. What my friend is submitting is not aligned with cultural protocol. Aboriginal people are a diverse mob. There's, I think 38 unique mobs here in Victoria alone, and the training will be Victorian specific, Koori specific. That's First Nations, Aboriginal and Torres Strait Islander people living in Victoria, but more importantly, traditional owner led through the Victorian Aboriginal Legal Service under Nerita's leadership. So there's sort of 2 points I wanted to make there, that not only is it specific to specialised modules in areas of law, but it's specific for Victorian legal profession. And it's wonderful that we're having this conversation as a legal profession and hopefully being able to offer that in the future for our practitioners in this state.
I might ask you, Adam, a question that's come up in the Q&A, and I hope I'm interpreting this question right, that talks about the potential for saturation of the training. And how do we make sure that there's thinking in terms of the entire legal profession, how do we make sure that the training continues to be meaningful in a way that is owned by the profession and continues to be engaged with, rather than a tick box exercise? I'm thinking of some online modules where people, anti-discrimination modules where there's not the deep engagement that you would hope and expect in terms of that type of work.
I think, Tim, from my perspective, I think this is going to be multifaceted. And by that, I think if you look at the legal profession as a systems change is going to take time. And so I think we're going to have to come at this through multiple ways. From a young person going into the law through university, how do we start to embed this and have this conversation happening at a university level? So when everyone's going off and learning about their Priestley 11, how is these concepts and these concepts being embedded to the university syllabus? Then you come out of that and you go into PLT. How does, then PLT is obviously around how do you, practical legal training, how do you start to look at how you practically apply some of these issues through the cultural capability framework? And then the next level, of course, is then you go into your CPD and education requirements. So I think the thing for me is, how do we make this as part of the way we teach and educate around the operations of the law? And as said, particularly here in Victoria, how do we talk to the practice of law in Victoria and the nuances around this capability framework, which has been designed for First Nations clients and people within the law, and make it actually embedded into what we do? So again, from an LIV perspective, we're looking to make sure our seminars, our conferences start to have this as an ongoing thematic. So it's part of the way we work, versus, to your point, Tim, a tick and flick box. This is not about a once-off, you go off and do some cultural capability and, Bob's your Uncle Jack and off you go. This is actually about saying we as a profession are committed to having a constant dialogue around this, learning, hearing, and actually building it into the way we work. And part of the way we work is also about how do we learn? How do we learn from each other? How do we learn through formal training and other things? And actually embed it into the way the system is actually developing, versus the biggest concern I think any of us would have is people see this as a compliance exercise. This is not about compliance. This is about changing culture. And culture has to be much more systemic and much more integrated than just, I've done my 1 point or whatever it might be that people think they need to do.
I'm going to ask Nerita a question, but then I'm going to ask Fiona a question just for your purposes, Adam, in terms of the vote. So, Nerita, I think there's two questions that are probably related that I can put together, and that's really in terms of particularly thinking, I think, about the criminal justice system and engagement in the criminal justice system. Is it intended that this framework be applicable to all points of entry into the legal system? So thinking about police, lawyers, caseworkers in the courts and the court systems, and what might be done where there is a lack of engagement with the framework. And I think that's connected to, in particular, thinking about the courts and thinking about high volume courts, the magistrates court in particular, and that pressure on legal practitioners to do things fast, get instructions fast, and make submissions quickly. Are we confident the courts will be on board in terms of this framework and how they might amend that practice or their practices to ensure cultural capability? So there's a few jumbled things there, sorry, Nerita, but...
Okay, not a problem. And just for those who are putting questions into the Q&A and chat, I'm trying to answer as many as I can in between answering questions live. Look, at the moment, this framework is tailored to the legal profession. So it can apply to law students, lawyers, barristers, of course, judicial officers as well. And in terms of developing the framework, that's why we targeted engagement to be broad and wide. It doesn't cover off on police. In terms of training police members, this has been something that the Aboriginal Justice Caucus has tackled and worked with police to develop models on, and they have their own cultural capability framework and training modules that they do regularly. We do hope that police officers who act as prosecutors will, of course, take up this opportunity and encourage them to do so, particularly with the new police commissioner coming on board. In terms of courts, it's always a fine balance engaging with courts, and we are hoping that with champions like Magistrate Pryor and others in the space, that they will start to work to change their practices. And we're seeing this prior. There's been in the past real resistance initially to changing their practices and procedures, but then when they've seen the benefit that it brings in terms of the matters coming before them and their own decision making, they often do give in a sense. I think that's all of those varied points. Tim, if I can just be a little bit cheeky, which is practically my MO at this point, I think that question really highlights the fact that what we are missing and what I think will come through treaty processes is that we are still working from an outdated concept of what the legal system is and should be. We have never interrogated that and done that work. And certainly I think we heard this through your Rook, and we saw inkling of this in some of their recommendations. And I hope that people who are listening to this webinar and interested will engage with our Justice Through Treaty project, which is really doing that work of building what is a theory of change for the legal system, and then what that looks like in terms of implementing it.
Absolutely. Fiona, we've got a question from an attendee about the training that will eventually be developed pursuant to the framework. Is it envisaged that the sessions be linked to CPD for legal practitioners?
Fortunately, it's not something I can control. And I think one thing I would like to say about that is I really encourage people not to think about this framework as a way simply to get their 10 CPD points. It will be that, it will contribute to that. But this is much more than just ticking off a CPD requirement. It requires reflection, it requires engagement with material that will be new and often quite confronting for people, and it will require reflection on how we do our work. And so that's not really something that fits super well into 10 hours of the different categories of CPD. So yes, many of the sessions that people do will meet the requirements for some of the CPD, but please don't think of it as a compliance exercise.
Well, I think that's all we have time for in terms of questions, just as we wrap up. And so sorry to people who have put questions in the chat, but I think we've answered most of them. If I can say a huge thank you to all of our amazing panelists today. We're really incredibly grateful to have had you so generously share your time, expertise, and your experiences in the legal sector. And to our two amazing Auslan interpreters, Brooke and Therese, thank you so much for your excellent interpreting today. We are very appreciative. And thanks to everyone who has joined us in the audience today. A huge amount of people, I can see from everyone who said where they were and what country they were dialing in from. It's encouraging to see so many people engaging with such an important topic, and everyone from someone who said they were a receptionist and want to build their capability in this area to people who mentioned a whole bunch of resources like the National Legal Assistance Workforce Strategy agreed with the Commonwealth. So there's all these great pieces of work that are happening. Nerita wrote an answer to the importance of this type of work happening in legal education institutions and the tertiary sector. So I want to make sure that that's on the record as something that's really important. So we encourage everyone to review the framework in depth and reflect on opportunities to expand your practice. Thanks for the question from someone. A link's been put in the webinar chat to the framework directly. Please keep an eye out for future updates related to First Nations cultural capability training delivered by VALS. If your question wasn't answered or if you have questions after this webinar that you'd like to ask, you can email Project Manager Georgie House at ghouse, that's all one word, GHALSE, at vals.org.au. I know Georgie put her contact details in the webinar chat as well if you have any questions. As you leave the webinar, there will be a small feedback survey that will pop up for you to share your thoughts. So we really encourage you to fill that out. I've seen it. It will barely take 2 minutes of your time. So we'd really encourage you to do that. A reminder that if today's discussion raised any issues or concerns for you, to call Lifeline, or for Aboriginal and Torres Strait Islander people to call Yarning Safe and Strong on 1800 959 563 or reach out to 13 Yarn, or for Aboriginal and Torres Strait Islander men, for Dadi Munro's brother-to-brother line. Those contact details will be shared in the chat section. Thank you all again. Thanks to Nerita, to Ash, to Adam and to Fiona in particular for joining us. And we hope to see you next time at a VALS webinar. Thank you very much.